Mm. Hi guys, good evening. Welcome to another Mahamarathon of one subject of SEBI Grade A 2025, that is company law, right? So before this, we have conducted the Mahamarathon for economics subject, and now this is the Mahamarathon for company law, right? And you know that around 15 days are left for your SEBI Grade A Phase 1 examination. So the discussions that we are going to have here, right? The questions that we are discussing, that we are going to discuss here, they are very important for the upcoming examination. Many questions out of these discussions we will be finding in the actual examination. Got it? Chaliye, so let's start the discussion guys without wasting time. Here is the question number first, and I need all your participation in the session. आप सभी का participation required होगा, तभी यहाँ पे you can have out of this session. ठीक है, you can have something out of this session. ठीक है जी, चलिए स्टार्ट करते हैं. सबसे पहले क्वेश्चन नंबर फर्स्ट इज, एज पर कंपनीज एक्ट 2013 द अमाउंट ऑफ डिविडेंड once declared must be deposited in a separate account in a scheduled bank within how many days from the date of declaration? So options are 2 days, 3 days, 7 days, 5 days or 10 days. You all have to participate guys. Yes, guys, do let me know. You all have to participate. What is the right answer according to you? So right answer is option number D, that is within 5 days, right? So यहाँ पे within 5 days के अंदर जब भी यहाँ पे dividend declare हो रहा है उसके within 5 days के अंदर that has to be deposited in a separate account. Yes, Vaishali is saying option number this one, that is D. So that is why option number D is the correct one. Guys, you all have to participate and do mention the question number as well. ठीक है, क्वेश्चन नंबर भी मेंशन करना है आपको साथ में. Question number second is, as per the Companies Act 2013, if a dividend declared by a company remains unpaid or unclaimed within 30 days of declaration, the company must transfer the total amount of unpaid dividend, unclaimed dividend to the unpaid dividend account in a scheduled bank within how many days? 7 days from the expiry of 30 days, 15 days from the expiry of 30 days, 30 days from the expiry of 30 days, 21 days from the expiry of 30 days, or 45 days from the expiry of 30 days. Please do mention the question number as well. Yes, friends, tell me what is the right answer here. So right answer is option number A, that is 7 days from the expiry of 30 days. तो जब यहाँ पे डिविडेंड डिक्लेयर किया गया है, राइट, इफ दैट इज unpaid within 30 days, then in that case उस 30 days के खत्म होने के 7 days के अंदर that has to be transferred to the separate account, that is unpaid dividend account. So Vaishali saying option number A. Yes, option number A is correct here. Question number third, as per section 124 subsection 5 of the Companies Act 2013, any money lying in the unpaid dividend account which remains unpaid or unclaimed for a period of 7 years shall be transferred to which of the following? Options are investor protection and awareness fund, Reserve Bank of India's dividend protection fund, investor education and protection fund, national dividend settlement fund, or none of the above. So yes, there's a guy named UPSC struggle. Guys, please mention the question number, I request you. क्वेश्चन नंबर प्लीज मेंशन करिए यहाँ पर, ठीक है, सो दैट आई डोंट गेट कंफ्यूज्ड आप कौन से क्वेश्चन का आंसर कर रहे हैं. यस, टेल मी व्हाट इज द राइट आंसर हियर. एवरीवन प्लीज मेंशन द क्वेश्चन नंबर. सो Vaishali is saying option number C. Okay, option number C is the right answer. Investor Education and Protection Fund, that is IEPF, section 125, right? So IEPF will be established as a part of section 125, right? So in section 125 that will be जो IEPF यहाँ पे constitute हुआ है उसमें basically जो amount है वो transfer कर दिया जाएगा. Question number fourth is, as per the Companies Act 2013, every company shall at its first annual general meeting appoint an auditor who shall hold office. Options are from the conclusion of the first AGM till the conclusion of the third AGM and thereafter every third AGM. From the conclusion of the first AGM till the conclusion of the sixth AGM and thereafter every sixth AGM. From the date of incorporation till the end of first financial year and thereafter every sixth AGM. From the date of appointment till the board of directors decide otherwise, or none of the above. So which of the statement is correct here? Guys, please mention the question number. जो question number mention नहीं करेगा उसका option, उसका यहाँ पे participation I will not count, right? Okay, so UPSC struggle is saying option number B. Yes, guys, everyone. Please do let me know. Vaishali saying option number B. Yes, option number B is the correct one. That is from the conclusion of the first AGM till the conclusion of the sixth AGM and thereafter every sixth AGM. Question number 5th, as per the Companies Act, the first auditor of a company other than a government company shall be appointed by the board of directors within how many days? Options are 15 days from the date of incorporation, 30 days from the date of registration of the company, 60 days from the date of registration of the company, 90 days from the date of registration of the company, or 45 days from the date of registration of the company. The question is, sir, इसी टाइप के क्वेश्चन एग्जाम में आएंगे? Yes, you can go through the previous year paper as well, and also in the upcoming examination these kind of questions are asked. So what is done basically, आपका provision is directly asked in the examination, so that is why I always suggest for the Companies Act you have to go for the Bare Act. Bare Act से रेफर करिए, there is nothing better than Bare Act. Bare Act is the perfect source for the preparation of Companies Act, guys. Directly provisions are asked in the examination, and this is the most easiest component and most scoring component according to me in the SEBI Grade A curriculum. So Vaishali is saying option number A, and UPSC struggle is also saying option number B. Option number B is the correct, not the A. That is 30 days from the date of registration. जब भी यहाँ पे date of registration इसके 30 days के अंदर board of directors has to appoint the first auditor of the company. क्वेश्चन नंबर 6, इफ द बोर्ड ऑफ डायरेक्टर फेल्स टू अपॉइंट द फर्स्ट ऑडिटर, ठीक है, अगर बोर्ड ऑफ डायरेक्टर फर्स्ट ऑडिटर को अपॉइंट नहीं करते हैं विद इन द प्रिस्क्राइब पीरियड, द मेंबर्स ऑफ द कंपनी मस्ट अपॉइंट सच ऑडिटर विद इन हाउ मेनी डेज? दैट इज 30 days at an annual general meeting, 60 days at an EGM, 45 days at a board meeting, 90 days at an extraordinary general meeting, or none of the above. Yes, Vaishali, that was a mistake, and these kind of mistakes you have to commit in these sessions but not in the actual examination. That is why we are conducting these sessions, so that you can commit the mistake, you can enhance your knowledge, you can gain confidence, right? And if someone is not participating, believe me, you will not learn something here. आप यहाँ पे बहुत कुछ नहीं सीख कर जा पाएंगे, ठीक है? So Mansi is saying option number D. Okay. Vaishali is saying option number B. No, option number D is the right answer. That is 90 days at an extraordinary general meeting. ठीक है, तो यहाँ पे if board of directors are not able to appoint, then they will inform the members, and members within 90 days they will conduct the extraordinary general meeting, and in that EGM the first auditor will be appointed by them, who shall hold the office till the conclusion of the first AGM. Question number 7th, the first auditor appointed under section 139 subsection 6 of the Companies Act 2013 shall hold office. Options are for a period of 3 years from the date of appointment till the conclusion of the 6th annual general meeting, till the conclusion of the 3rd AGM, till the conclusion of the 1st AGM, or none of the above. बताइए, फर्स्ट ऑडिटर जो है वो कब तक ऑफिस होल्ड करेगा? दिस इज द क्वेश्चन, एंड गाइस दीज आर द टेक्निकल क्वेश्चंस, ठीक है, जो आपसे पूछे जाते हैं एग्जाम में. सो इफ यू डोंट हैव द क्लैरिटी यू विल डेफिनेटली कमिट दीज क्वेश्चंस रॉन्ग. सो वैशाली सिंह ऑप्शन नंबर बी. ओके, मानसी सिंह ऑप्शन नंबर बी. यस फ्रेंड्स, एवरीवन डू लेट मी नो. So right answer is option number D, that is till the conclusion of the first AGM. We are talking about the first auditor, right? So first auditor appointed by the company shall hold office till the conclusion of the first AGM. In the first AGM, another director will be appointed who shall hold the office till the conclusion of the 6th AGM. So this is the sequence, right? So you have to remember. That is why I told you this is a technical question, right? You might commit it wrong. So yes, you have committed wrong, right? चलिए कोई बात नहीं, वेल डन, एटलीस्ट यू गाइस आर पार्टिसिपेटिंग हियर. क्वेश्चन नंबर 8 इज इन केस ऑफ अ कैजुअल वैकेंसी इन द ऑफिस ऑफ एन ऑडिटर अदर देन द कंपनीज ऑडिटेड बाय द कंट्रोलर एंड ऑडिटर जनरल, सच वैकेंसी शैल बी फिल्ड बाय द बोर्ड ऑफ डायरेक्टर्स विद इन हाउ मेनी डेज? ऑप्शंस आर 30 days, 45 days, 60 days, 90 days, और टिल द नेक्स्ट एनुअल जनरल मीटिंग. बताइए, अगर कैजुअल वैकेंसी होती है तो वो वैकेंसी बोर्ड ऑफ डायरेक्टर्स कितने दिनों में फिल करेंगे? दिस इज द क्वेश्चन हियर. So right answer is option number A, that is within 30 days. Yes, so Nilesh is saying option number A. Yes, option number A is correct here, 30 days. ठीक है, great. चलिए, moving ahead towards the question number 9th. Question number 9th is saying where a casual vacancy arises due to the resignation of an auditor, such appointment made by the board shall, options are, be valid only for 3 years, require approval of the tribunal, be subject to approval by SEBI, be effective only after approval by the central government, या फिर also require approval by the company at a general meeting convened within 3 months of the board's recommendation. Yes, guys, do let me know what is the correct option here for question number 9th. So correct explanation is option number E, that is it also requires approval by the company at a general meeting convened within 3 months of the board's recommendation. Got it? Question number 10th. Under the Companies Act 2013, an auditor appointed under section 139 can be removed from office before the expiry of his term only. Options are by an ordinary resolution of the company in a general meeting, by the board of directors with the central government intimation, by a special resolution of the company after prior approval of the central government, by the audit committee subject to shareholders ratification, or by the registrar of companies based on shareholder complaints. So Nilesh is saying option number C. Okay, for question number 10th. Yes, friends, everyone do let me know. Mansi is saying option number C. Yes, guys. So right answer is option number C only. That is by a special resolution of a company after prior approval of the central government. So yes, a special resolution needs to be passed by the company in the general meeting, and after that, central government approval is also required. Got it? Question number 11. As per the Companies Act 2013, the minimum number of directors required in the case of a public company is options are 3, 2, 1, 5 or 15. Minimum number of directors required in the case of public company. This is the question. Read it very well. Don't be confused with private company. It is a public company we are discussing here. Nilesh is saying option number A. Okay. Vaishali is saying option number A. Mansi is saying option number A. Yes, option number A is correct. That is minimum 3 directors are required in case of a public company. Question number 12 is the maximum number of directors a company can have under the Companies Act 2013 is options are 10, 12, 15, 20 or unlimited. Yes, friends, maximum number of directors. Nilesh is saying C. Yes, friends, everyone. So right answer is option number C only, that is 15 directors, right? So maximum limit is 15 directors. Question number 13. Under section 149 of the Companies Act 2013, a company can appoint more than 15 directors, right? So company can appoint more than 15 directors, but in what cases? Options are by an ordinary resolution passed at the annual general meeting, by board resolution with central government approval only if permitted by SEBI regulations, by approval of the registrar of companies, or by passing a special resolution in a general meeting. Nilesh is saying 13th ka E. Okay. Mansi is saying 13th E. Yes, friends, everyone. Vaishali is saying option number E. Yes, option number E is the correct one. That is by passing a special resolution at a general meeting. So if more than 15 directors need to be appointed, then in that case, a special resolution needs to be passed in a general meeting. Question number 14th is, as per Companies Act 2013, every company shall have at least one director who stays in India for a total period of not less than how many days during the financial year? And this question was asked in the previous SEBI Grade A examination. Options are 90 days, 120 days, 150 days, 182 days, and 240 days. So Manshi is saying option number D. Nilesh is saying option number D. Okay. Yes, friends, everyone do let me know. Shivani is saying option number D. So right answer is option number D, that is 182 days. So at least 182 days, at least one director shall stay in India for a period of not less than 182 days during the financial year. Question number 15. As per the Companies Act 2013, every independent director must give a declaration that he meets the criteria of independence. Options are only once at the time of appointment, at the first board meeting in which he participates, and thereafter at the first board meeting of every financial year, or whenever there is a change affecting his independence. Only when required by SEBI or the board of directors, every 6 months, irrespective of board meetings, or only before the filing of annual returns with the registrar. Nilesh is saying option number B. Mansi is saying option number B. Vaishali is saying option number B. Anshika is saying B. Lakshman Maheshwaram is saying option number B. Yes, option number B is the correct one. Shivani is saying option number B. Guys, you all have given the right answer. Option number B is the right one. That is at the first meeting in which he participates, number first. And after that, at the first meeting of every financial year. And after that, whenever there is a change affecting his independence. Got it? So you all have given the correct answer, guys. Very well done. Question number 16. As per the Companies Act 2013, a small shareholder means a shareholder holding shares of nominal value of not more than, options are 500 or such other sum as may be prescribed, rupees 10,000, rupees 15,000, rupees 25,000, or rupees 20,000. So we are talking about the small shareholders. So what should be the holding of a small shareholder? What should be the holding? What should be a holding of a shareholder in order to be considered as a small shareholder? Nilesh is saying option number E. Mansi is saying option number E. Okay. Yes, friends. Even if you do not know the answer, you can simply make a calculative guess, guys, because this is what you have to do in the actual examination too. Because all the questions you might not be able to attempt in the examination, so you need to make a calculative guess, right? Okay. So Nilesh, Mansi, Lakshman, Anshika, Vaishali, you all are saying option number E. Yes, option number E is correct. That is rupees 20,000 or such other sum as may be prescribed. Well done, guys. Question number 17. As per the Companies Act 2013, where no provision is made in the articles of a company for the appointment of the first director, who shall be deemed to be the first director until directors are duly appointed? Options are the registrar of companies, the subscriber to the memorandum who are individuals, the board of directors appointed by shareholders at the first AGM, the central government nominees, or the promoters of the company. This might be the technical one according to me. Now let's see how many of you are giving the right answer. Nilesh is saying option number B. Mansi is saying option number B. Yes, guys, everyone. Ankul is saying option number B. Lakshman B. Yes, Anshika is saying option number B. So till now, everyone is saying option number B here. So right answer is option number B only. That is the subscribers to the memorandum who are individuals shall be deemed to be the first directors until the directors are duly appointed. Right? Well done, guys. Question number 18. As per the Companies Act 2013, in a public company, unless the articles provide otherwise, not less than filling the blanks of the total number of directors shall be the person whose period of office is liable to determination by retirement of directors by rotation. Options are 1/5, 1/2, 1/3, 2/3, 3/4, or all directors. Yes, guys, participation थोड़ा सा कम हो रहा है. Everyone. Question number 18th. Nilesh is saying option number C. Okay. Ankul is saying 2/3. That is option number C only. Lakshman is saying option number C. Yes, guys, everyone. Do not worry about the wrong attempt, right? Because these sessions we are conducting so that you can commit the mistakes here only. Okay. So don't worry about the wrong attempts. No one is going to judge you here. No one is going to penalize you here. Tell me, so only 3 students have participated, Nilesh, Ankul and Lakshman, and they have given the right answer. That is 2/3 of the total number of directors shall be the person whose office is liable to determination by retirement of directors by rotation. Yes, Shivani has also given the right answer. Well done. Question number 19. Who is the competent authority to allot the director identification number that is DIN under Companies Act 2013? So options are Registrar of Companies, SEBI, NCLT, Ministry of Finance, and Central Government. Nilesh is saying option number E. Okay. Mansi is saying option number E. Vaishali is saying option number E. Anshika is saying option number E. Right. So till now everyone has said option number E. Yes, option number E is the right answer. That is central government. So Lakshman, Shivani, you all are saying option number E. Yes, so option number E, that is central government is the competent authority to allot the director identification number to the directors. Right. Question number 20th. As per section 157 of the Companies Act, every company shall furnish the DIN of all its directors to the registrar within how many days of receiving intimation under section 156? So options are 15 days, 30 days, 45 days, 60 days, or 90 days. Yes, guys. So actually, every company has to furnish the DIN to the registrar. So this is the provision that within how many days of receiving the intimation, company shall furnish the DIN, the intimation of DIN to the registrar. This is the question here. So, guys, please mention the question number. Right. Mansi is saying option number B. Nilesh is saying B. Shivani, Ankul, Anshika, Lakshman, you all have given B as an answer. Yes, B. Sorry, option number A is the correct one. That is within 15 days, right? So when company would be basically here furnish DIN to the registrar, that shall be within 15 days here. ठीक है? So within 15 days के अंदर यहाँ पे company has to furnish to the registrar. तो यहाँ पर किसी ने भी सही आंसर नहीं किया है. This is the catch here. यहाँ पे I think सब follow कर रहे हैं किसी एक person को. Guys, थोड़ा सा लॉजिक लगाना है, ठीक है, फॉलो नहीं करना है. Question number 21. Under the Companies Act 2013, which statement about an additional director is correct? So options are holding office permanently once appointed. It cannot be someone who failed appointment in a general meeting holds office till next AGM or due date of AGM whichever earlier. Must be appointed only by special resolution in general meeting. Holds office for a period of fixed 5-year term or can be appointed only by shareholders in EGM. गाइज डू नॉट फॉलो एनीवन, जस्ट बी योर ओन. ठीक है, जो आपको सही लगता है वो अटेम्प्ट करिए. आई थिंक यहाँ पे फॉलो किया जा रहा है किसी एक पर्सन को, इसीलिए सबके आंसर गलत होगा. ठीक, किसी ने भी सही आंसर नहीं दिया था. यस, सो 21 अंकुल इज सेइंग ऑप्शन नंबर बी. Nilesh is saying option number B. Mansi is saying option number B. Yes. MSSPPI. I don't know how to pronounce it. She's also saying option number B. Anshika, Shivani, you all are saying option number B. Yes, option number B is the correct one. That is, it cannot be someone who failed appointment in general meeting, holds office till next AGM or due date of AGM, whichever earlier. Well done, guys. Question number 22nd here. As per section 165 of the Companies Act, what is the maximum number of directorships a person can hold at the same time, including alternate directorships? Options are 15 companies, of which maximum 7 can be public, 25 companies, of which maximum 12 can be public, 30 companies, of which maximum 15 can be public, 20 companies, of which 10 can be public, or 10 companies, of which maximum 5 can be public companies. Okay, so Nilesh has given his answer. Nilesh is saying option number D. Mansi is saying option number D. Ms. Pesi is saying option number D. Shivani, Ankul, you're all saying option number D. Yes, so option number D is the correct one. That is 20 companies, of which maximum 10 can be the public companies. So this everyone has attempted correctly. Very good, guys. Question number 23rd. When does a director vacate office under section 167, subsection 1, clause B of the Companies Act 2013? That is absent from all the board meetings for 3 months only without leave. Absent from all board meetings for 6 months with or without leave. Absent from all board meeting for 9 months with or without leave. Absent from all board meetings for 18 months with or without leave, or absent from all board meetings for 12 months with or without leave. Yes, so Nilesh is saying option number E. Okay, Mansi is saying option number E. Miss P saying option number E. Lakshman is saying option number E. Yes, so till now everyone has mentioned option number E only. Hanji guys, what is the right answer? Right answer is option number E only, that is absent from the all board meetings for 12 months with or without leave. Got it? Question number 24. Under section 169 of the Companies Act 2013, how can director not appointed under section 242 be removed before the expiry of the term? So options are by ordinary resolution after giving him an opportunity of being heard, only by special resolution, cannot be removed before expiry, only with the central government approval, or only by board of directors. बताइए. So how can a director be removed before the expiry of term here? Question number 24th. Ankul is saying option number A. Lakshman is saying B. Mansi is saying A. Okay. Hanji guys, read the question carefully. Miss P is saying option number B. Yes. What about others guys? Confused between A and B? So right answer is option number A, that is by ordinary resolution only after giving him an opportunity of being right. So no special resolution is required, only it can be done through the ordinary resolution only. Question number 25th. As per section 173 of the Companies Act, when must a company hold its first meeting? Within 7 days of incorporation, within 30 days of incorporation, within 45 days, within 60 days, or within 90 days? Tell me, we are talking about the first board meeting, right? So when should be a first board meeting be conducted? Mansi saying option number B. Nilesh is saying option number A. Okay. Lakshman is saying B. Vaishali is saying option number B. Nilesh is also saying B now. So till now everyone is saying option number B. So right answer is option number B only, that is within 30 days of incorporation. Anshika is also saying option number B, right? So within 30 days of incorporation, company must hold its first board meeting. No, it is not D Ankul, it is B only. Okay? Chaliye. Question number 26 is, what is the maximum gap allowed between two consecutive board meetings under section 173 of the Companies Act? 60 days, 90 days, 120 days, 150 days, or 180 days? We are talking about the maximum gap between the two consecutive board meetings under section 173. Nilesh is saying option number C. Okay. Lakshman is saying option number C. Anshika is saying option number C. Ankul is saying option number C. Okay. Yes, guys. So right answer is option number C only, that is 120 days. So maximum gap allowed is 120 days between the two consecutive board meetings. Okay. Question number 27th is, as per section 174 of the Companies Act 2013, what constitutes the quorum for the meeting of the board of directors? So options are 1/4 of the total strength or 2 directors, whichever is higher, half of total strength or 3 directors, whichever is higher, 1/5 of total strength or 1 director, whichever is higher, 1/3 of total strength or 2 directors, whichever is higher, and minimum 3 directors irrespective of strength. Yes, we are talking about the quorum. What is the meaning of quorum? Quorum is the minimum number of directors required to conduct the board meeting successfully, right? So that is the quorum. So what is the minimum number of directors required to conduct the board meeting? This is the question here. Yes, so Nilesh is saying option number D, that is 1/3. Okay. Ankul is also saying option number D. Yes, friends, do let me know. Do participate. Make a, you can say, calculative guess here. Try to attempt it based on your knowledge, based on your study. Anshika is saying option number D. So right answer is option number D only, that is 1/3 of the total strength or 2 directors, whichever is higher. Got it? Yes, so Nilesh, Ankul and Anshika, you have given the right answer, guys. Question number 28 here. XY, this is a kind of, you can say, case study which can be asked in the examination too. So XYZ Limited has a board strength of 9 directors. Two of them are physically present in the meeting while one participates through video conferencing. What is the status of the quorum? So options are: quorum not met, minimum 9 directors required; quorum not met, video conferencing not counted; quorum requires at least 5 directors, therefore not satisfied; quorum requires at least 3 directors physically present, therefore not satisfied; quorum requires at least one third, that is 3 directors, including video conferencing, satisfied. Yes. So Nilesh is saying option number D. Okay. Yes, friends, do let me know. Question number 28. This is the kind of application based question, case law, case study based question, and this can be asked in the examination. Okay, so Anshika is saying option number E. Shivani is saying option number E. Okay. Lakshman is saying option number E. Guys, right answer is option number E only. That is, quorum requires at least one third. That is 3 directors, right? So 3 directors, including video conferencing also. So if anyone is participating through the video conferencing, that is also considered for the purpose of the quorum, right? So one, we have discussed one third members, right? So one third with the one third of 9 directors are basically three. So out of them, two are participating physically and one is through the video conferencing. So quorum is met here. Meeting can be conducted successfully. That is why option number E is the correct one. So those who have given the E, their answer is correct here, right? Question number 29. When must a company constitute a stakeholders relationship committee as per the Companies Act 2013? Options are: if it has more than 500 shareholders at any time during a financial year; if it has more than 1000 shareholders only irrespective of other security holders. Option number C is if it has more than 1000 shareholders and debenture holders but not deposit holders. Option number D, only when directed by SEBI or the central government. Option number E, if it has more than 1000 shareholders, debenture holders, deposit holders or other security holders at any time during a financial year. Nilesh is saying option number E. Okay. Guys, read the question carefully before attempting it. Lakshman is saying option number E. Anshika is saying option number E. Mansi is saying option number E. Yes, option number E is the right answer. That is, if it has more than 1000 shareholders, debenture holders, deposit holders, or other security holders at any time during a financial year, then company must constitute a stakeholders relationship committee. Yes. So Ankul, you are saying option number C. No, option number E is the right answer, Ankul. Question number 30th is under section 181 of the Companies Act. When does the company's board or require prior approval of the general meeting for contributions to bona fide charitable funds? Options are: when contribution exceeds 2% of net profit of the last financial year; when contribution exceeds 3% of average net profits of the past 5 years; when contribution in aggregate exceeds 5% of average net profits of the preceding 3 financial years; when contribution exceeds 50 lakh in a financial year; or when contribution is made to political parties. So little bit technical here, but let's see. Nilesh has given answer very promptly. So Nilesh is saying option number C. Mansi is also saying option number C. Ankul is also saying option number C. Okay, guys, you guys are very fast. Lakshman is saying option number C. Yes, guys, what about others? Right answer is option number C only. That is, when contribution in aggregate exceeds 5% of average net profits of the preceding 3 financial year. So you all have given the right answer here. Question number 31st. As per section 23 of the Companies Act 2013, consider the following statements. Statements are: a public company can issue securities through a public offer. It can issue securities by private placement. It can issue securities through rights or bonus issue. Listed or intending to be listed companies must follow SEBI rules. A public company cannot make private placement. Which of the above statements are correct? Options are 1, 2, and 5th only. Second, third, and fifth only. First, second, third, and fourth only. First, third, and fifth only, or first, fourth, and fifth only. So Nilesh is saying option number C. Okay. Yes, guys, do let me know. What about others? What do you think? What can be the correct answer here? Yes, Lakshman, Ankul, Mansi, Anshika. Tell me, guys. So right answer is option number C only. That is first, second, third, and fourth only. Fifth statement is incorrect. That is a public company cannot make private placement. Yes, public company can make the private placement. That is why this is incorrect, and hence 1, 2, 3, 4 are correct here. Okay. Question number 32. According to section 23, subsection 2 of the Companies Act 2013, consider the following statements regarding the issue of securities by a private company. So options are: a private company can issue securities by way of rights issue or bonus issue. It can issue securities through private placement. A private company can issue securities through a public offer. Rights and bonus issues must comply with the provision of the Companies Act 2013. Private placement must follow the provisions of Part 2 of Chapter 3 of the Companies Act. Which of the above statements are correct? First, second, fourth, and fifth only. First, third, and fourth only. Second, third, and fifth only, or first, second, and third only. So Nilesh is saying option number A. Okay. Haji, do let me know. Mansi is saying option number A. Shivani is saying option number A. Lakshman is saying option number A. So right answer is option number A. That is first, second, fourth, and fifth. Third statement is saying a private company can issue securities through a public offer. This is incorrect. Private company cannot issue securities through public offer. Okay, so that is why this is incorrect, and hence first, second, fourth, and fifth. That is option number A is correct. Yes, Anshika and Ankul, you all have given the right answer here. Question number 33rd is: under Section 25, subsection 1 of the Companies Act 2013, a document offering securities for sale to the public after allotment by a company is deemed to be a statement in lieu of prospectus, a red herring prospectus, a self prospectus, an information memorandum, or a prospectus. So Mansi is saying option number E. Nilesh is saying option number A. Okay. Lakshman is saying B. Ankul is saying option number B. Guys, right answer is option number E only. That is a prospectus. Only Mansi has given the right answer. It shall be deemed to be a prospectus here. Okay. Question number 34th is: as per section 26, subsection 8 of the Companies Act, a prospectus shall be considered invalid if it is issued after how many days from the date it was delivered to the registrar? Options are 30 days, 45 days, 60 days, 75 days, or 90 days. So once it is delivered to the registrar, then within how many days it shall be issued? This is the question here. So Nilesh is saying option number E. Lakshman is saying option number E. Yes, guys, everyone, do let me know. So right answer is option number E, that is within 90 days, right? So if it is released after the 90 days, once it was delivered to the registrar, then in that case, it shall be considered invalid. So only Nilesh and Lakshman have given the right answer. Question number 35th is: under section 27, subsection 1 of the Companies Act 2013, a company can vary the terms of a contract or the objects stated in the prospectus only with options are approval of the board of directors, approval of a shareholders through special resolution in a general meeting, approval of the registrar of companies, approval of the central government, or approval of the Securities and Exchange Board of India. Nilesh is saying option number B. Mansi is also saying option number B. Anshika, Lakshman, Mansi, Nilesh, you all have given option number B. So option number B is the correct one. That is, approval of shareholders through a special resolution in a general meeting is required in order to vary the terms of a contract or the object stated in the prospectus. Yes. So Shivani, you have also given the correct answer. Got it, guys. Chaliye, question number 36 is, as per section 29 subsection 1, every company making a public offer shall issue its securities in physical certificate form only, either in physical or dematerialized form, in bearer form as per investor preference, only in dematerialized form, or in both physical and electronic forms simultaneously. So Nilesh is saying option number D. Okay. Lakshman is saying option number D. Shivani, D. Yes, friends. What about others? Mansi is saying option number E. So right answer is option number D only, that is only in dematerialized form. This is clearly mentioned in section 29 subsection 1 that every company making a public offer shall issue its securities only in dematerialized form. Got it? Question number 37th is, before making a second or subsequent offer of securities under a shelf prospectus, a company must file an information memorandum with the registrar, a red herring prospectus with SEBI, a statement in lieu of prospectus, a certificate of compliance from the auditor, or a private placement offer letter. Nilesh is saying option number A, Lakshman is saying option number B. Okay. Anshika is saying A, Mansi is saying A. Yes, guys, what about others? So right answer is option number A only, that is an information memorandum with the registrar, right? So once shelf prospectus has already been submitted with the registrar, then in that case, information memorandum shall be required till the validity of the shelf prospectus. Got it? Question number 38. If applicants have already applied or paid for securities before any change occurs in the information memorandum, the company must forfeit the application money, ignore such applications, delay allotment until approval from SEBI, inform applicants about the changes and refund money within 15 days if they wish to withdraw, transfer the funds to an escrow account for 1 year. Nilesh, Ankul, Mansi, you all are saying option number D here. Anshika is also saying option number D. Right answer is option number D. That is, inform applicants about the changes and refund money within 15 days if they wish to withdraw. Question number 39. A company proposing to make an offer of securities may issue a red herring prospectus. Options are after the issue of final prospectus, after the closure of subscription, prior to the issue of a prospectus, after allotment of securities, or only after SEBI approval. Yes, Lakshman is saying C, Nilesh is saying C, Mansi, option number C. So right answer is option number C, that is prior to the issue of a prospectus. So company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of a prospectus, right? Question number 40th is, a company issuing a red herring prospectus must file it with the registrar 10 days before opening of the offer, at least 3 days before opening of the subscription list, immediately after closing the offer, within 7 days of SEBI's approval, or along with the final prospectus. So Nilesh is saying option number B. Ankul is saying option number B. Mansi is saying option number B. Anshika is saying option number B. So right answer is option number B only. That is at least 3 days before the opening of the subscription list, right? So well done, guys. So, and this is the homework question for you. So which you are not supposed to attempt in the chat box. You need to attempt in the comment box. Those who will be giving the right answer of this question, their name will be reflected in the next session. Question is, after the closing of an offer made through a red herring prospectus, the company must file the final prospectus with only the registrar of companies, only SEBI, both registrar and SEBI, stock exchange only, and the Ministry of Corporate Affairs, right? Again, I would repeat here. Do not attempt this question here. This question you have to attempt in the chat, in the comment box, not in the chat box. And those who will be giving the right answer of this achievers question, their name shall be reflected in the next session that we will be conducting next week, right? And guys, before closing, one important announcement, that if you are aspiring to become RBI Grade B officer, and if you are preparing for RBI Grade B 2026 examination, here we have come up with officers batch, that is a foundation batch for 2026 RBI Grade B examination, where we are going to cover each and everything comprehensively, right? Even if you are from the non-commerce background, guys, do not worry, each and everything will be covered very comprehensively. First we will be focusing on your foundation building, then after that एग्जाम के लेवल पर हम चीजों को समझेंगे. सो लॉन्च डेट है 6 जनवरी की, बट आज से एनरोलमेंट स्टार्ट हो चुके हैं. 6 जनवरी से बैचेस स्टार्ट होने वाली हैं. अर्ली बर्ड एनरोलमेंट स्टार्टेड फ्रॉम टुडे, दैट इज 26 से ये स्टार्ट हो चुके हैं. सो दोज हु आर एस्पायरिंग टू बिकम आरबीआई ग्रेड बी ऑफिसर, गाइज, यू कैन हेयर एनरोल फॉर द कोर्स. कैसे एनरोल करना है, लिंक इज गिवन इन द डिस्क्रिप्शन. सेपरेटली यू कैन विजिट टेस्टबुक.com, उसको मैं अभी आपको बताता हूँ किस तरीके से आप कर सकते हैं. सिमिलरली इफ यू आर प्रिपेयरिंग फॉर अदर एग्जामिनेशंस लाइक आरबीआई, सेबी, नबार्ड, पीएफआरडी, सिडबी, क्योंकि देयर इज द ह्यूज ओवरलैप, राइट? और अगर आप इन सारे एग्जाम्स की प्रिपरेशन कर रहे हैं, देन इन दैट केस गो फॉर द रेगुलेटरी बॉडी सुपर पैक. इस सुपर पैक की हेल्प से आप यहां पर इन सारे एग्जाम्स की प्रिपरेशन एक साथ कर पाएंगे. ठीक है, आपको अलग अलग कोर्स, अलग अलग एग्जाम के लिए अलग अलग कोर्सेज की जरूरत नहीं है. यू कैन हैव सिंगल कोर्स, दैट इज रेगुलेटरी बॉडी सुपर पैक, एंड इस सुपर पैक के थ्रू यू विल बी प्रिपेयरिंग फॉर ऑल दिस एग्जामिनेशन साइमल्टेनियसली, विच मीन्स जहां पर आप 10x कॉस्ट पे कर रहे थे, वहां पर सिर्फ और सिर्फ 10% कॉस्ट नीड टू पे, एंड उसके अलावा उसके साथ ही आप यहाँ पे सारे एग्जाम की प्रिपरेशन कर पाएंगे. कैसे एनरोल करना है, गाइस? 2 ऑप्शंस आर देयर. फर्स्ट, लिंक इज गिवन इन द डिस्क्रिप्शन. तो पहली बात तो आप डिस्क्रिप्शन में लिंक दिया, वहां पर आप जा सकते हैं. सेकेंडली, सेपरेटली यू कैन विजिट हियर टेस्टबुक.com. सिंपली गूगल पर जाइए, टाइप टेस्टबुक, ओपन द फर्स्ट लिंक हियर, जो हमारी वेबसाइट है वहां पर जाइए. देन यू कैन सी एट द टॉप द ऑप्शन ऑफ सुपर कोचिंग, क्लिक हियर. उसके बाद लेफ्ट हैंड साइड पे यू कैन सी आपको बहुत सारे एग्जाम्स देखने के लिए मिल जाएंगे. यू कैन स्क्रॉल डाउन एंड फाइंड रेगुलेटरी बॉडी एग्जाम्स. क्लिक हियर रेगुलेटरी बॉडी एग्जाम्स में यहाँ पर जाइए. आरबीआई ग्रेड बी में अगर आप आरबीआई की प्रिपरेशन कर रहे हैं, अगर आप आरबीआई के अलावा और भी एग्जाम की प्रिपरेशन कर रहे हैं, देन गो फॉर द रेगुलेटरी बॉडी एग्जाम सुपर पैक. पैटर्न विल बी सेम. यू हैव टू सिंपली स्क्रॉल इट डाउन. आपको यहाँ पे स्क्रॉल डाउन करना है. यू विल गेट टू नो ईच एंड एवरीथिंग अबाउट दिस सुपर पैक, व्हाट ऑल एग्जाम्स आर कवर्ड हियर. देन फर्दर उसके बाद यहाँ पे यू विल बी गेट टू नो अबाउट द फैकल्टी. यू विल गेट टू नो अबाउट द डेमो क्लासेस ऑफ द फैकल्टी, ताकि आप देख सके कि हाउ वी आर कवरिंग द थिंग्स हियर. यू विल गेट टू नो द चैप्टर वाइज ई बुक्स, राइट? यू विल गेट टू नो अबाउट द, यहाँ पे आपको प्रैक्टिस क्वेश्चंस देखने के लिए मिलेंगे. आफ्टर गोइंग थ्रू ऑल दिस, इफ यू फील दैट यस दिस कोर्स इज गोइंग टू हेल्प यू, देन यहाँ पर डिफरेंट वैलिडिटीज अवेलेबल, 24 मंथ्स, 12 मंथ्स, 6 मंथ. आपको यहाँ पे क्या करना है, यू कैन सिंपली सी द प्राइस, बट दिस प्राइस यू आर नॉट सपोज टू पे. आपको यहाँ पर जाना है अप्लाई कूपन में. यू कैन सी हियर, क्लिक हियर, रिमूव द कोड विच इज ऑलरेडी देयर. इसको रिमूव करिए एंड अप्लाई द कोड प्रकाश. ठीक है, ये कोड यहाँ पर अप्लाई करिए प्रकाश. इसको अप्लाई करते ही यू कैन सी द ड्रास्टिक डिस्काउंट यू वुड बी ऑब्जर्विंग. यू कैन सी हियर, आपको ड्रास्टिक डिस्काउंट यहाँ पर देखने के लिए मिलेगा, राइट? सो दिस इज द प्राइस दैट यू हैव टू फाइनली पे, either in 3 EMIs or you can say you can pay full amount as well. So this is how you have to proceed. ठीक है, इस तरीके से आपको कोर्स में एनरोल करना है. एंड गाइस, लाइक दिस ईयर बहुत सारे एग्जाम्स आपने देखे हैं, आरबीआई, सेबी, नबार्ड, पीएफआरडी, सिडबी, आईएफएससी. गाइस 2026 भी आपका बहुत एग्जाम आप देखने वाले हैं. ठीक है, इससे रिलेटेड डेडिकेटेड वीडियो आई विल डेफिनेटली कम अप विद. सो दिस इज हाउ यू हैव टू प्रोसीड गाइस, एंड इस तरीके से आप यहाँ पर प्रिपेयर कर सकते हैं. ठीक है, सो डू नॉट फॉरगेट to apply the code Prakash, with the help of which you will be getting the maximum discount. I have shown you how to apply the code here, and do join my Telegram group. After joining this, you will be in touch with me. Those who would be Those who want to have the PDF of this session, guys, you just need to ping me there in the Telegram group. I will be separately posting the DM. I will be posting the PPT PDF of the session separately. जो भी यहाँ पे ping करेगा, ठीक है? So thank you very much. This is all. Again, Lakshman, I told you that PDF of the session you can get through my Telegram group. So join it and just ping me there. I will share the PDF. Got it? So thank you very much, guys. This is all, and do not forget to answer the achievers question if you want to see your name in the next session. So bye bye. Take care. I wish